Good afternoon. I am joined by my esteemed colleagues. I will be moderating our conversation today, and these are meant to be informal, interactive for everyone who's joining us. If you didn't have a chance to submit questions, please feel free to use the Q&A function on Zoom, which is at the bottom of the screen, to type in questions, and we will address them, answer them in real time. We were supposed to be joined by some others, but looks like you'll have to deal with the four of us. I think everyone's in good hands. My name is Morgan Geller. I practice franchise law and general business law. I am joined by Lauren Forenza. Say hi, Lauren.
Hello, how is everybody?
Ben Wolkov.
Hello.
Jeremy Ben David. And collectively, we head the corporate practice group at AXS Law Group. We focus on real estate issues as well, mergers and acquisitions, and essentially addressing all of the miscellaneous legal issues that come up during a business's life cycle. And right now, obviously, we are working with a lot of our clients to guide them through the issues, pitfalls, and questions that have arisen as they're getting ready to reopen amidst COVID-19. So what we're going to focus on today is really just those legal items that a company can explore having while they are getting ready to reopen, such as waivers of liability and internal procedures regarding workplace safety and all of that good stuff. So again, this is question and answer format, not meant to be boring or a lecture. And guys, on our end, you know, Andrew Cromer made it as well. You just joined at a perfect time, Andrew. We're just doing some welcome introductions. So welcome.
Sounds good. Apologies for being tardy.
No worries. So with that, I will kick it off. I'm just going to pose some questions for the group, and feel free and interrupt one another, and let's get this legal powwow going. So the first thing that we're going to address is waivers. Obviously, businesses in general, you know, to some extent have waivers of liability. But now that we have a specific risk, especially on my end dealing with fitness clients or other personal services, clients have asked, you know, what can I do to protect myself if someone by chance gets COVID-19 in my facility or my property? So the waivers really fall into two different categories, employee type waivers and customer waivers, or waivers that you're dealing with third parties. So generally, does anyone want to take a stab at explaining what a waiver of liability is, or a release in general for a company?
I'll take it. So I think a lot of clients have come asking about these waivers because they are concerned about opening up and potential liability for claims related to COVID. So if an employee or a guest gets sick from COVID and is claiming that it occurred while they were working for the employer, or a guest, say, at a hotel, then the purpose of the waiver would be to limit the employer's liability in this instance. When we're talking about employee waivers, obviously those are the ones between employees and the employers. Generally, any type of waivers in the employment context are a little unfavored just because the rationale is there's not very equal bargaining power between the employer and the employee. So it's not necessarily fair to the employee. So that's kind of the starting place from employer waivers. And also, workers' compensation type claims cannot be waived. So I think there's a question of where does COVID fall within all of this? I think it comes down to if you think the workplace is dangerous. Under OSHA, if there's an imminent danger, then you can have these sort of waivers, but is COVID something that's going to fall out of that? And I think that's going to fall on a fact by fact basis on the particular surrounding that this waiver would be in place for. So for instance, if you had a medical setting and you were making healthcare providers provide services without any sort of protective gear, if you had them sign a waiver in that instance, I don't know that it would necessarily limit your liability because you're almost acting in a negligent type of manner.
I would ask Morgan, are you seeing this in the context of mostly fitness, which would make sense? I'm just thinking to myself, like, are we inching towards the day when we go eat out at restaurants and they have us sign a waiver before we sit down for our meal? Like
I mean, I personally had to sign a electronic waiver for a hair salon. So what some businesses are doing, in addition to having legal documents in place, is collecting customers' credit card information beforehand. That involves a whole nother slew of legal issues and privacy, which we won't get into today. And part of the process of getting the customer information was doing the online waivers. And obviously, as group fitness classes open up, I think there are certain activities that carry with them higher risks than others, obviously. When you're in an enclosed area, working out, sweating, breathing near people, I think in those instances, it's part of, to me, weighing how that looks from an employee standpoint or a customer standpoint, because you don't really want to turn off the customer. But for the most recent example is a fitness company, but they already have a waiver in place. So what is recommended from the legal side is that now we know that there's this risk of coronavirus. So there should be, what I've seen is having a separate waiver that specifically refers to COVID-19, illness, wrongful death, or types of damages that can arise from COVID-19. And in that case, the customer, client, whoever it is specifically acknowledging the risk. So the benefit of having something separate is that there isn't an argument that the waiver doesn't specifically include COVID-19, which we knew was a foreseeable risk. So if there's an opportunity to get a COVID-19 specific waiver, that's what I've been recommending. And at the end of the day, people should always remember that in order for a waiver to be enforceable, it needs to be voluntary and knowing. So if you are doing the waivers online, it's critical that you have necessary checkbox that requires the person to click manually, saying by clicking or by acknowledging below, I'm entering into this voluntarily. And there's technology that you can do that with as well.
Isn't there a practical consideration here? How could you ever prove that you got COVID by entering to a restaurant or a gym? I understand best practices, are to obtain these waivers. But in reality, since it takes so long for a person, to test positive for the virus, it's gonna be really, really difficult to trace back to where it was contracted. You know, unless there is some robust tracing system, which there isn't, and I don't know if there are plans for one. You know, I get it from the employer perspective. You want to have these things in place, but in reality, if you don't, you know, it's going to be hard for someone to say, "Hey, I got sick," and you know, at your restaurant or at your gym.
There was one, I think recently I heard in the news that there was like 100 cases were traced back to one, I forget what kind of establishment it was, but it was in the news lately. So you definitely don't want to be that business.
I think the more important point of all of it is like, you want to make sure internally with your own employees that you're following CDC recommendations and making sure you're not being negligent as it relates to, you know, having sick employees work and then they're, you know, that get out and then a bunch of people get sick at your establishment and then it becomes an issue.
Yeah.
You know, and in that case, I'm not sure you can waive negligence anyway. So.
Yeah, that might constitute a gross negligence where even though you can't maybe make or prove a direct correlation, you can probably prove by they knew that this person was sick with COVID and they didn't take the necessary or the guidelines that were being pushed to isolate this person and keep them at home to prevent the rest of your workforce from getting sick.
Yeah. I mean, you obviously don't want to open up the door to be put into that basket, right? But I guess my point being is it's going to be, you know, I think a bit difficult to tie it all back. You know, that sort of dovetails into another topic that's interesting, right? Is what other precautions should employers be taking, right? And generally what I tell clients is follow the CDC guidelines, right? You follow the CDC guidelines, all their suggestions. You'll have a good legal standing here in case an employee or visitor tries to allege a case against you for negligence. You know, you're following the rules that have been set out, or the recommendations, I should say, and guidelines that have been set out. And you would be, I think, likely to overcome any sort of negligence action.
There's also the regulatory side of it. Andrew, maybe you want to talk a little bit about the OSHA angle too.
Yeah, you know, what's been amazing during this process is that, you know, OSHA, CDC, they've actually been quite clear, right? And you go to their website and they have very helpful FAQs and they have hypotheticals and they have best practices. So, you know, if you haven't been to the CDC's website or OSHA's, you should definitely check it out and just kind of browse. And they even divide content based on like what your business is, right? Like, are you a supplier? Are you, so, you know, there's really good tidbits on there, you know, but from the highest level, you know, you want to obviously make sure you're taking the necessary precautions internally, making sure you have PPE available for all the people at your office. You want to post what the guidelines are. You want to make sure people are wearing masks. If you decide you want to take temperatures, which you can do, and they've been specific about how that is okay. And, you know, there's a way to go about it, right? It's going to be a medical record, right? So if you do take temperatures and you decide to record temperatures, you want to make sure those are being securely held somewhere. You know, if someone has COVID or someone, you know, you're not going to know if someone has COVID if you take their temperature, but let's say they have 101 fever, right? You don't want to yell out in front of everybody, John, you need to go home. You have a 101, you know, there is a proper way to go about that. And, you know, it also involves like where you take temperature. Do you just take it in front of everybody? And how do you tell someone that, you know, they have a fever, they should go home, they should meet with their medical professional and, you know, presumably, hopefully get a COVID test and hopefully they report back if it's positive. And if it's positive, you know, how do you go about informing the people that you work with, that they've been in contact with, that they should self-isolate and then performing a deep clean on the area and investigation of where they might have been, what they might have touched, informing, you know, your local health department, the CDC, that someone at your office, you know, tested positive for COVID. And this links back to what I was saying previously about making sure you're you're going through the necessary steps to make sure, you're not being negligent about having folks test positive or knowing someone might be sick and taking no action.
Yeah.
Oh.
Yeah, I was going to say one other thing, for employers, before you take any action about testing or inquiring about medical conditions, you should always check the CDC website as well as the EEOC website to see any changes. EEOC, Equal Opportunity Commission, and that'll provide you some good guidance. But piggybacking off what Andrew said, you should be able to take someone's temperature, but you have confidentiality obligations to be considered when doing so, as well as you got to be cognizant of the questions you can ask employees, right? You're not allowed to ask them if they have a compromised immune system, but you could ask them if they're having a cold or any flu symptoms. So in laying out a framework to follow for the company, employers should frequent, both the CDC website as well as the EEOC website.
And on a regular basis, because I think they're adding updates so much, you want to make sure that you're up to date if things are changing.
And I think you can sign up to receive alerts, email notifications as well through these government organizations. So that's something that's always recommended as well, even for us. So on the topic of employee safety, how should an employer deal with someone who refuses to come back to work, even though shelter in place and stay-at-home orders have been lifted? Sorry.
I can take that. So the question is, shelter in place has been lifted. We're at phase 1, maybe even phase 2. An employee refuses to come back to work. So, it's a difficult question to answer, right? Because you want to make sure the employee feels comfortable, right? And at the same time, you don't want to terminate them because they have a medical condition that isn't allowing them to come back to work. So I think, obviously having a conversation with the employee is paramount. Understanding if it's a fear of becoming sick, is it because they're perhaps sick, right? And obviously if they're sick, right, they should stay home, right? And an employee refusing to come back, even though it's been lifted because they're ill, you should not require them to come back to work. Now, if it's because they're uncomfortable with the environment in the office, you should assure them of all the practices that you've taken to ensure their safety. But if they're still not satisfied with that and they have, a emotional reaction to coming back to work, I think it's a decision that you should make as to whether they can continue to do their job function away from the office. And if it's essential that they're in the office, then, that's a business decision that you'll need to make. Right. And there's obviously risk reward, right? And the reward being you need someone in there doing these tasks, and that's just essential. And the risk being, if you terminate them because they're not sick and you require their job requires them to be in the office, then, you'll take the risk if litigation comes as a result of that. But certainly you'd have defenses. So, there's no black and white answer to that question, but I think going through the normal channels of having that conversation, assuring them of all the safety, and then understanding whether in fact their position does require them to be in the office, at least over the next few weeks while things return to normal. All things the same, 4 months ago, if someone refused to come into the office, you'd call it job abandonment. So, I think at a certain point, we're not necessarily there, but sooner than later, we're heading in that direction.
Does anyone else have anything to add on that before moving on to the next topic? No? All right. So, I imagine, depending on the culture of a company, that the legalese and the, what may be deemed intimidating language to an employee or a customer even, may not be the route that a business may want to take. So for those businesses, are there any other alternatives or other options apart from waivers that a business can use to get the acknowledgments and information that they need from customers or employees?
I think we've seen a lot of businesses doing questionnaires, and I've seen a lot of healthcare places doing that as well, where it's not necessarily a waiver that you're required to sign off on, which can, I understand, be intimidating to some people, but it's more just, have you experienced any of these symptoms in the last couple of days? Other questions about flu-like symptoms, and I think it's a little less, it's a little more appealing of an option than like a legal binding waiver that someone has to sign. I think businesses can also put up notices on their storefronts or on their websites if they have any sort of procedures that they're doing that are special to this time. I know a lot of businesses' websites have stated if they're doing curbside pickup, what you're to do when you get there, if you're supposed to wear a mask and things of that nature. So I think that those are some options that you can do without having to maybe potentially scare a customer away with a legal document.
I've also seen businesses, you know, if taking one's temperature in the office is not a good fit for your business for whatever reason, I've also seen acknowledgements, right, where you send each employee home with a stack of 50 blank questionnaires. You know, there's a spot to take your temperature at home. You indicate if you have any COVID symptoms, and then you sign, right? And you get into the office, you turn it in, right? You took your temperature at home, it was 98.3. If you have no fever, you know, no loss of taste, etc., sign your name, date it. You know, that's a medical record. It gets stored in a safe place, and that sort of, you know, takes away the issue of taking someone's temperature and then having that conversation in the office and you know, trying to keep that piece of information confidential. You know, a lot of offices these days are open offices, so it's not so easy just to have those private conversations. So I've also seen that.
Good stuff. Has anyone else seen anything worth sharing or a specific issue that's come up with a client or matter, obviously without divulging confidential information?
Well, I think generally, you know, it's prudent amongst every business to really stay up to date with what's going on. Guidelines are forever changing, not just nationally, but within your own state and municipality. You know, here in Florida, for example, you know, restaurants and hotels were allowed to open up about a week ago, but certain cities held out until today, actually, the 27th, to allow restaurants to open up. Similarly, hotels in Miami aren't allowed to open until June 1st. So I think, you know, it's really important to stay up to date with county guidelines and restrictions, as well as city guidelines and restrictions. Because like I said, even within the county itself, certain cities may operate a bit differently.
And how can a business, as we know, just because things are opening doesn't necessarily mean that everyone's going to open at the same time. It doesn't necessarily mean that all consumers have decided that they want to go back to normal. So when a business is considering to reopen, how can they balance the fact that it's legal to reopen with the inherent risks of reopening? You know, so if a client or, you know, someone says to you, well, just because I'm allowed to open, should I open? You know, so what goes into that decision?
Yeah, I mean, it's a good question, right? In every case is needs to be looked at a bit differently. The cost of reopening, you know, may not be minimal. In installation of the plexiglass dividers, depending on what kind of business you operate, PPE equipment for staff and employees, testing, temperature checks like we've discussed, hand sanitizer, cleansing, in between shifts or tables or classes, just the cost could add up. On top of that, you're more likely than not going to be operating at a reduced capacity, 25%, 50%. So, your expenses are going up, your top line gross revenue is coming down. I can definitely see, in certain cases, it just may not be worth it from a business standpoint to reopen.
I also think you have to look at your individual business. Take two restaurants, for instance. One might have much more of an open air kitchen where it's possible for employees in the back of the house to do their job and not really have too much close contact and maybe maintain that 6 feet away from each other. And then a restaurant right next door that might not be the case. And they might have a very small kitchen, and it's nearly impossible for people to do their job without physically touching other people. So I think that's a big consideration as well.
Yeah, I think sadly, perhaps, economics are going to be the driver, right? I don't think anyone truly knows what's going to happen. So as Jeremy noted, if it doesn't make sense financially to open, perhaps they won't. But if they need to open and they're willing to take the risk, if there is a risk, because they just need to start, making money, then, that might be a risk that most are willing to take.
Yeah. And something that just to add to this kind of business side of our discussion, since the business does interplay with the legal oftentimes, is that I've been telling customers, and I've been telling clients, and I've been seeing this just as a regular consumer, is that whatever you're doing internally in your company, it's important to communicate that to all of your people within your company and to the public. So, like Lauren said, it's important that the customers know what's expected of them so that the process is seamless. So if you want all your customers to show up already wearing a face mask, they know that. And if you're going to take their temperature, that's something that you should let them know before they arrive, so you don't have any customer service issues. But it's also advised to communicate as well, because I think it's going to take some time for consumers to become comfortable with this new way of life. So whatever you can do from a business standpoint to ease concerns, let them know what you're doing, safety is your priority, that goes a long way in building goodwill for your brand.
Just going off that, I was listening to, I think it was a Miami Herald article yesterday, and the question popped up, well, what do you do if a customer takes off their mask when they're in your restaurant? And the response was, well, what would you do if someone took their shirt off? Like, I guess that's become our new standard, our new normal. So I just thought that was a tidbit.
Yeah, businesses can mandate that, right? Like the old saying, no shoes, no shirt, no service.
No shoes, no mask, no service.
Yeah,
There's there was, I think I read this morning, if anyone saw it, I saw a headline that there's a lawsuit in Texas for someone refusing to wear a mask. I think it was an employee, might have been an employee. Did anyone see that?
You didn't see that one?
Look at that. But yeah, it's definitely an interesting thing to pay attention to see what kind of lawsuits are going to arise from this, because there will always be easy ways to sue people in the US, unfortunately.
Yeah, and I think that the difficult part is, it's, even though it seems like we've been living with COVID for such a long time now, and a lot of these lawsuits, we haven't seen them play out, right? So we don't really know how a lot of this is going to shake out at the end.
Exactly. Do we have any questions from our attendees at this point? I'll give like maybe 30 seconds if anyone wants to type in a question in the Q&A. No? All right. I think we've covered pretty much everything in terms of.
I think one other thing, though, that we, it's worth discussing. This gets back to sort of what Andrew discussed before, right? It may seem obvious, but it's definitely, worth noting is, how employees are treated. You still got to be cognizant of, discrimination laws within the workplace. If between, let's say, males and females, if you're permitting, a male employee certain benefits to deal with the pandemic, and the female employee is looking for the same, and they're in the same position, same role, you don't want to open yourself up to any claims by forbidding those same accommodations to the female employee that you may provide to the male employee in the same role. You can very easily open yourself up to a gender discrimination claim. So you still got to be cognizant of the typical, labor claims in the workplace as you navigate the pandemic guidelines.
And to that note, I think even more so that would be likely than the gender thing is you might think that you're coming across being a concerned employer if you express your concern to any older workers that you have, but that's the same thing, and that's going to get you into the same problem because you could have an age discrimination claim. So while you're just maybe coming from a good place, just be careful about that.
Yeah, that's a really good point. With age discrimination and that's definitely could be a possibility.
Mm-hmm. So I think now would be a good time if anyone has some concluding thoughts, expert insights of where we go from here.
I'd love to hear Jeremy's thoughts.
He dubbed himself. I think the takeaway right now is really just be checking the guidelines and the rules on a daily basis if you're an employer or if you're a manager in control of people coming into your place as either a customer or an employer. And as long as you're doing the best that you can do following those guidelines for your business to keep everybody safe, you're not going to ever be able to completely avoid any liability, but that's going to put you in the best position. So you should just be really vigilant about that and just taking all your best efforts.
Yeah, and one other thing is, do your research. I think, folks can learn a lot from what their colleagues and competitors are doing in terms of just best practices. I mean, I know in the legal profession, I'm on a listserv with other attorneys at other firms, and there's chatter going back and forth of, how offices are dealing with this, what precautions they're taking. And I've learned a bunch just by speaking with other attorneys. So I think, you can learn tips and tricks, not, from speaking to your colleagues, competitors, friends, in addition to obviously looking at guidelines that are being put out.
Yeah, and I think just to reiterate sentiments brought up earlier, really leverage these agencies that are providing really, really good content. And, they are actually supporting all the different employers to make sure that there is no red tape, right? And if there is red tape, to clarify that it doesn't apply, right? If perhaps there could be a HIPAA concern, they're going to tell you it's not, right? So instead of trying to ask your lawyer and trying to understand if there are HIPAA considerations on an issue, they're going to spot it and say there's not. So I think, do yourself a favor, stay abreast in all the information. And of course, the five of us are here should you have any questions, and we can help navigate you through any of these issues.
And be sure to visit our firm's website. We have a COVID-19 resources page where we have uploaded articles, and all of our webinars are recorded and posted on a go-forward basis, and we've done them for our past ones. So there are any specific topics that come to mind, we are open to ideas and welcome feedback.
All right.
Cool.
Thanks,
All
everyone.
right.
See ya.
Thanks for joining. Bye.
Yeah.